Okay, I think we can get started now. Good afternoon and welcome to the Center for Critical Korean Studies at the University of California Irvine. My name is Joseph Jun and I'm the director of CCKS. As you know, because of the current COVID-19 pandemic, CCKS, like many other organizations, has had to change gears and adopt to our new normal. So it's good to see so many of you here today. I see the participant number ticking up as we speak. Our event today is the second in a sort of mini-series that we have about Korea and the COVID-19 pandemic. And I'd like to acknowledge Professor Kyunghin Kim and our administrator, Joo-hoon Shin, who worked so very hard to bring you this event. For those of you who are joining us for the first time, please let me just say a little bit about the center, the CCKS. We're in our fourth year, so we're relatively new, but we've established ourselves as a focal point for Korean studies here at UCI, and for connecting the university to the larger community in Orange County and the greater Los Angeles area in general. I could speak for a long time about what our center does, our top-notch faculty, our degree programs, and our commitment to serving the community. But let me just boil it down to one central function. We are here to protect Korean studies in the US and to ensure that it flourishes for many years to come. Here's a plea. If you care about Korean studies and thinks it deserves a place in US higher education, then please consider supporting CCKS at UCI. In the next year, we're up for our grant renewal. So we need to come up with a 50% match to receive the second half of our grant funding from the Academy of Korean Studies, which is our major funding source. This means that we need to raise $500,000 in order to unlock the $1 million of AKS funding. While the current COVID-19 crisis has made certainly our task more difficult, it's become even more important than ever. Crises are times when centers, of course, like ours, become less of a priority in a university administration, and we are determined to make sure that CCKS remains on firm ground. So right now, we're setting up a series of meet and greets. We just had one actually last week. Over the next few months, over the summer months, designed to introduce ourselves and what we do here at CCKS to prospective donors and other allies in our community. Rakib Hawk in our development office is coordinating these efforts, and you can contact him at the number or email on the screen. You can also contact me directly. You can also donate on our CCKS webpage, which is listed right there in the image. And as always, CCKS is grateful for your support. We would literally not exist without you. And so let me introduce today's panelists. This is Law and Privacy in the New Normal, Long-Term COVID-19 Containment Strategy. Our moderator for today's event will be Michelle Goodwin. She's the director of the Center for Biotechnology and Global Health Policy and a professor of law at UCI. Michelle holds the Chancellor's Professorship at the University of California Irvine and is the founder and director for the Center of Biotechnology and Global Health Policy and its internationally praised Reproductive Justice Initiative. She's a prolific author and an acclaimed constitutional law scholar and a bioethicist. Professor Goodwin has published with Forbes, Salon.com, the LA Times, the New York Times, the Chicago Sun-Times, the Houston Chronicle, the Christian Science Monitor, among others. She is the author of several highly acclaimed books, including Policing the Womb, which chronicles how women's reproduction has become the political scapegoat in Congress and legislatures across the US, resulting in the rise of policies and practices that dramatically erode reproductive liberty. She is an elected member of the American Law Institute and an American Bar Foundation Fellow. Our first presenter today is Kyungshin Pak. He's the director of the American Law Center, professor of law at Korea University. Kyungshin, or KS Pak, is a Senate professor at Korea University School of Law. He researches, litigates, lobbies, and speaks in the areas of freedom of speech, privacy, net neutrality, web accessibility, digital innovation, and intellectual property. Relevantly, he is a co-founder and executive director of OpenNetKorea.org, which has a publication on COVID-19 surveillance in Korea, a member of Global Media Freedom Initiative high-level panel of experts, a board member of Global Network Initiative, and an advisor to Freedom Online Coalition. He served as commissioner at the Korean Communication Standards Commission, a presidentially appointed internet content regulation body from 2011 to 2014. Our second presenter is David Kaye. He's a UN Special Rapporteur on the freedom of expression and a professor of law at UCI. David Kaye is a clinical professor of law at UCI, sorry, reading the titles and the descriptions, and the United Nations Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression. His 2019 book, Speech Police, The Global Struggle to Govern the Internet, explores the ways in which companies, governments, and activists struggle to define the rules for online expression. And our third speaker is Noyeon Pak. He's the director of the Cyber Law Center and professor of law at Korea University. He teaches and makes research on international economic law, legal aspects of cybersecurity, data protection and digital trade, and negotiation/mediation. He has advised Korean governments on these areas. For example, he attended the 4th and 5th UNGGE on information security by advising Korean delegations. He has been regularly involved in international dialogues with American, Chinese, European, Japanese, and Russian experts on cybersecurity and data protection. He is responsible for the Cyber Law Center at Korea University Law School. Without further ado, I will turn things over to Michelle.
All right, well, it is a pleasure to be with you all, our viewers, as well as my colleagues domestically and also abroad. The topic that we're dealing with today could not be more urgent for our times, examining the legal issues surrounding what has taken the world by storm in terms of this pandemic. There's much to be said about this. I look forward to interacting with our speakers this evening, or depending upon what part of the world you're in, it may not be the evening, but I think that we'll just get started on this. And as I welcome Professor Park to start us off, I want us to think about what the implications happen to be for the most vulnerable people around the world and communities that now have to endure what this pandemic brings to us all. And what does this mean in terms of global collaboration and cooperation? What roles have certain countries played to bring us forward in better ways, and where are the ways in which we've been held back? With that, I'll turn it over to you, Cass.
Yes, thank you for the introduction. Before I start off, just want to remind everyone that this is co-hosted by not just CCKS, but also the center that I had, the American Law Center of Korea University, and also Cyber Law Center of Korea University, which is headed by the other Professor Park, who is also a panelist, and also Korea Law Center at UC Irvine Law School, which doesn't have a panelist here, but is with us. I'll start presentation here. Let's see. Okay. All right. Can you guys, are you guys seeing the PowerPoint? Okay, good. Korea is just about the only major country affected by COVID-19 that has neither closed its borders to any country nor has imposed long-term general lockdowns in any geographical area. Now that some countries have shown success, but in the past they have done border shutdowns and lockdowns, but Korea has not. So the question is, how was this made possible? What does Korea have that other countries do not, especially in terms of law? Section 76-2 of Infectious Disease Prevention Act allows comprehensive location tracking of patients, possible patients, people who have come into contact with patients, and the possible contactees, people who might have come in contact with patients. All the tracking is done despite their will, without judicial approval. And you all know that location tracking for criminal purposes requires judicial approval. Now, was this good for prevention purposes? Well, people point to massive testing as a secret of success for Korea, but that was made possible only because Korea has this tool to find out who to test. Korean law authorizing this non-consensual, non-judicial location tracking of patients and contactees allowed identifying only worldwide targets of testing. Now, most of the criticisms in the international media on Korea's privacy was on public disclosure of the information on the patients. Sometimes disclosure of too much stigmatizing information, or other times disclosure of the identity at all. Now, these are all valid concerns, but Korean government has addressed them by progressively reducing the information that has been disclosed. For me, a bigger issue, both from privacy perspectives and from prevention purposes, is government's initial acquisition of the information.
Yes, I'm going
Yes.
to ask just one moment if you can actually broaden the screen. And I think that there's a way to see it so that
Okay.
I think our guests only see a micro version of your.
Really?
This is what I'm learning.
Okay, let me see.
Yeah, I think you could just start the presentation.
Okay. Let me start again.
Yeah, if you start the slideshow.
All right, let me do that. Okay, how about this?
That's great. That's great. Thank
That's
you.
much better.
All right.
Thank you.
Good.
Sorry for that interruption, Cassie.
No, it's okay. It's okay. So, so more than disclosure, the government's acquisition is more important for privacy purposes, because if you look around, this is a world's only law that authorizes non-consensual and non-judicial location tracking, at least among democracies. I looked through US public health law. I'm sure that Michelle is an expert on this. And the US only has Section 264 mandatory quarantine, but there's really a mandatory quarantine, but it doesn't really allow location tracking to mandatory tracking of the patients all across the different locations. So, disclosure disclosure is not efficacy enough. It's not effective enough for purposes of prevention, because disclosure does not guarantee notifications to the people who might have come in contact with them, who might have come into contact with the patients unknowingly. And also, when you find the patients, patients talk about where they have been, who they came into contact with, but the information volunteered by patients may not be accurate. And sometimes for privacy purposes, they may not be able to reveal accurately and fully their movements. So just to back up what I just said about this is Korea's only law. I mean, you can look at where different countries are at, and Korea is the only country at the top, together with Israel, that have this non-consensual mandatory tracking. and it's done through cell tower search. So everyone that has phone, not just smartphone, all mobile phones leave their digital traces at the cell towers located across the whole country. Now, Israel has a similar system, but what they are doing is this is done through emergency order. This is it's not like peacetime legislation. This is kind of converting the use of their cybersecurity information for disease purposes. But Korea's law allows ordinary time location tracking, even outside the emergency. And when did Korea acquire this law? Well, back in 2015, during the MERS outbreak, if you look at the graph, the blue represents the number of cases, MERS cases in Saudi Arabia. So and if you look at around 2015, you can see the red spike. And that's when Korea was the only country where MERS was a pandemic. By the time, I mean, people jokingly said it should not be called MERS break. It should be called course break. KORS outbreak. So what did we learn there? Well, the lessons are nicely captured by this public statement issued by Korean Society of Infectious Diseases, which is the mainstream association of epidemiologists of the country. And they say they publicly, I mean, if you read the Korean words, they actually promise to contain MERS if we have these three things. What are they? Full disclosure of all contactees, despite the side effects, and tracking all the patients and contactees, and then leaders by the experts. So that's the lesson, and that lesson was turned into this non-judicial, non-consensual location tracking law. And this shows the breadth of the information that the authorities can access. So location data from mobile phone carriers, immigration records to check, when the person came into the country, CCTV footage, credit card records, transpass records, all of that can be acquired by the police and Korean CDC. And of course, not all of that is made available, but all of that is used to track down all the possible contactees before they start spreading. Now, we talk about the massive testing system and how important that was for Korea's success. But let's look at the numbers. Korea has 50 million population. So far, Korea has tested only about 1 million people. But the disease has been contained down to less than 100 new cases a day. Compared to the US has a 300 million population, so only 6 times larger, and has done 20 million tests, but the virus still is not contained. The US still has like 40,000 new cases a day. So maybe it's not the testing, it's not the quantity of the testing that matters. Maybe it's the quality of the testing. I mean, let's look at the numbers on the right side. So you all know how the new cases are much larger in the US than Korea. If you look at the number of tests, that's the number of tests per 1,000 people. And if you look at Denmark, US, Italy, New Zealand, Canada, these are all countries that still have a much larger number of new cases per day, but they all have done more testing per thousand than Korea. And I mean, what I noticed is that if you look at Korea's CDC guideline and also WHO guideline, they do not recommend testing people without symptoms. But in Korea, there are many, many tests done on people without symptoms and without any diagnosis at all. For instance, if a patient is found working in a building where 2,000 people work, then all 2,000 people will put into testing without any symptom or diagnosis. And maybe this is important because the proportion of asymptomatic carriers and asymptomatic and infectious carriers is very large compared to other diseases. And Korea has done this. Korea could do this because it has this mandatory tracking law that identifies at-risk areas and at-risk people early before they start spreading. Now, Korean law suffers from big privacy problems, and there are easy problems to point out. As I shown you earlier, police are the intermediaries, and police investigate on all crimes. So this can be kind of a way to sidestep search and seizure process, sidestepping warrant. Also, the bodies allowed to do this surveillance is more numerous than I believe necessary. Not just health authorities, but also elected local government chiefs, who tend to who have this political tendency to serve the majoritarian will of the constituents, whose judgment will be blinded by their desire to serve the public. They cannot really be, their decisions cannot be really balanced between privacy and public interest. And also targets are not just patients or suspected patients, contactees, and even suspected contactees. So we see a situation where 20,000 people in 20,000 people who were in a certain area, Itaewon, that's where all the clubs and the hip places are. All 20,000 people who were in that area for one night, they were all identified and contacted for recommended testing. And also the data to be accessed are much broader. Credit card records, much broader than location information. Credit card records, medical records. And on top of that, all this information, if you remember this slide, there are many agencies involved. There are sources of the information and the receptacles of the information. So to make the information sharing easier, they set up this website where all the 28 national agencies can instantly share the information. Those are easy problems to point out. Actually, I'm working with the civil society to file a constitutional challenge against that law, just to smooth out those easy problems. The broader scope, the too broad scope of information, too broad scope of surveillance bodies. But even if all those easy problems are fixed, there is the hard problem remaining, where the government can still do non-judicial compulsory access, and the question remains: when this is the world's only system, does it really pass international human rights standard? Which is what I want to hear from our next panelist, David. So I looked around to see whether this can be justified under other countries' law. Especially, I looked at the U.S. Supreme Court precedents on administrative search, which allows warrantless, non-judicial access to the information. And there are I noticed three rules of thumb arising from the American standard for administrative search. First, it is much easily allowed under in closely regulated industries like firearms, drugs, and mines, but it's not so easily accepted in building code inspections and occupational safety health inspection and hotel guest inspection. The Supreme Court has said for these inspections, because they do not involve closely regulated industries, the warrants should be sought for. And also binary searches are more readily allowed, like drunk driving test, airport check. There, they do not look for like continuous trajectory of a person. It just looks for yes or no, looks for answers to yes or no question. For instance, are you drunk or not? At the airport, do you have metal or not on your body? Those are binary searches. And also the third rule of thumb is that it should not be a cover for criminal investigation. Now, if we apply these three rules of thumb, we still have a difficulty in evaluating Korea's location tracking. It's not binary because you take a person and you look at the trajectory of that person through many days, even for a month, and it does not. And this is not closely regulated industries because it just concerns an individual. Now, it has nothing to do with the criminal case, and there is no evidence that it has been abused for criminal, the information has been diverted for criminal purposes. But still, there is not enough information to go on to evaluate the Korean system against international human rights standard. Now, Korean National Human Rights Commission, the country's human rights body, they have issued a recommendation, but only on the disclosure, but not on acquisition. Now, this concerns me because it is acquisition that seems to be more determinative on the efficacy of our prevention efforts. So this is my last slide. So the question is, should Korea be written off as an exception? Should be written this off as a cultural phenomenon, or do we need to confront Korea? Well, I think we should confront Korea because the non-judicial, non-consensual tracking has been more or less fully embraced by the public. Korea is forging ahead with more. For instance, we began electronically marking all the people who are entering clubs and norebangs. You all know what norebangs are, like karaoke type places where you sing. And we are using QR codes. So everyone who is going to these places will be marked and recorded in some national database system. And Korea is doing that because Korea has already obtained a lot of, accomplished a lot of success using non-consensual location tracking. So if you can track people's movement, of course, the thinking is that, of course, they can also find out whether the person has entered a certain place or not. Now, this is important. Confronting Korea's case is important because the rest of the world is reopening. And Korea is the only one that has the experience of leaving the businesses open. So shall we at least think about adopting the Korea's case in some modified manner? or shall we just stop Korea from, putting on a show for the whole world on, how it's done, and save Korean people from the surveillance hell? So can we call this, do we call this surveillance hell, right? Or shall we just say, every country should have its own solution because privacy is a culturally relative construct and we should all do what suits people? So that's a question that is pressing on me for now. Thank you.
That was absolutely great, KS. And, what I want to do is ask a couple of questions and then move on, because I want us to be able to have a dynamic discussion with all of our panelists. But I'm really impressed by what you brought to this conversation, including the non-consensual nature of the kind of tracking that was done in Korea and tying that to Israel, of course. And then asking basic questions about, is it testing or is it the quality of testing? In some strange and ironic way, one could read your presentation as fitting alongside Donald Trump, which I know you probably wouldn't want to do. But of course, he's been saying, you see, the more that we test, the more that there are these cases. But the reality is that these cases do exist. And then the challenge for our times, of course, is making sure that we're able to keep people as safe as possible and figuring out the way that we are able to do that while being able to preserve civil liberties and civil rights. So I'm wondering, and you can answer this now or when we open it up for larger discussion, about how you see the Korean case in relation to the US. In Korea, one could say there was an organized movement in terms of addressing this, whereas in the United States, it's been a bit haphazard. You see high amounts of deaths in New York, rising cases in Arizona, and no real coordinated response, federal or state. Are those some issues that you've also thought about? I know you've been focusing on the Korean case, and I want to, dive there too, but I also want us to look at this comparatively.
I haven't had a chance to look at it, but I still haven't heard any state actually most of attempts were based on people installing the apps on their smartphones. Mm-hmm. If you remember the slide that I showed you, all the countries and all the states, there were icons for some of the US states. They all rely on installation of apps first, and there's no law that can force a majority population into installing apps. Now, the cell tower, it doesn't require installation of apps. If you are using the phone, then the telcos already have the information, mm-hmm. and that's the information that government is accessing. Right. So I don't think I don't know clearly what Arizona or other states have done, but I don't think they have done, they have access.
They certainly haven't done that. But I wonder, I wonder if you would say that, look, even though Korea engaged in what seemed like robust proactive efforts, because those efforts were also overlaid with such abuses of civil liberties, that they didn't actually result in the ways in which lawmakers might have expected. So would the cautionary advice be, don't do that, US? Don't follow what we did, because it turns out you won't be, you won't be successful.
Well, I think that it is we haven't really had a discussion. On public disclosure, there has been much discussion in and outside the country, and we know what to do. And CDC and the authorities have reduced the amount of information that has been disclosed. Right. But on the idea that the government against people's will can still access the location data when they decide that you might have been or you were in a building, the same building as patients. That idea has never been really fully discussed even within the country. So I mean, out of my conscience really cannot like recommend either way to other countries or states because I know how contagious this disease is. This is just, and also so more contagious even without symptoms than any other disease that we have seen so far. And so many people are dying. I'll be very, very, it'll be mentally just impossible for me to really recommend one way or the other. But I think that we should, everyone should look at Korea's case.
As an example.
Yeah.
I agree. Well, I look forward to following up in a broader discussion with us all about the Korean case and what lessons it holds for the rest of the world, including what lessons it could hold for those of us here in the United States as well. What can we learn from this? Our next presenter is my colleague, David Kay, who I'm sure has much to say that actually builds upon your presentation, specifically in thinking about questions of civil liberties as part of a global response to these issues. David, I'm going to turn it over to you.
Great. Thank you, Michelle. And such a privilege to see you when we don't get to be in the same room for faculty meetings and all of that these days. And also on an incredibly busy day with the Supreme Court and all of your work. So I'm really happy to see you. And I'm also really happy to be following KS. I think KS, your presentation was excellent. I saw kind of an early preview of it when you presented it to a class of mine I mean, time is irrelevant during the time of COVID, but I think it was in April at some point when you were starting to think about this. And what I'd like to do is just spend a couple of minutes. I really don't want to spend a long time, but a couple of minutes thinking about the Korea example from the perspective of international human rights law. And KS made reference to human rights law and human rights standards a few times. And I think it's worth our thinking about whether, in particular, the non-judicial consent aspect of the Korea model is in fact consistent with basic human rights standards. But before I go into how I think those standards are articulated, I just want to emphasize something that I think we probably all feel to a certain extent, but maybe when we present, we don't always, at least in my case, don't always show that. I mean, we're all in a moment of great uncertainty. Like we're in a moment in which we really don't know all of the different aspects of the disease, of the way it spreads, of the long-term effects. And that, I think that uncertainty, it's not some extraneous factor. Right, that uncertainty plays into how we think about the kind of, you know, in Europe we talk about a margin of appreciation. It plays into the extent to which we accept some things that states might do now because they don't know, because they don't know what the impact of the disease and the long-term spread and pain of it might be. So I think that kind of humility, certainly on my part, is fundamental to how I see the human rights standards at issue here. And maybe we'll frame a little bit how I see, in particular, the amount of deference. And people who know me know I am not into deference to states at all. But in a time of emergency like the one that we're in, I think that to me is a kind of fundamental question. Like, to what extent are we willing to accept things from states that we would never accept in normal times? And so let me say a couple of words first about human rights law and the standards, and then I've written down a set of, I don't know if we could call them elements or principles that I think we should think about as we're looking at laws like Korea's law that KS so expertly described and analyzed. So when we're thinking about the issues of surveillance, we tend to look at one, maybe two different provisions of international human rights law. And what I want to just first highlight is Article 17 of the International Covenant on Civil and Political Rights, the Iccpr. Korea is a party to the covenant, as is the United States. And Article 17 basically protects the right to privacy against unlawful or arbitrary interference. So the standard generally is understood as arbitrary or unlawful. Is the interference with privacy? So for example, is the surveillance, is the collection of personal data arbitrary or unlawful? It's actually been more fully articulated by human rights experts in the human rights system of the United Nations and within the Iccpr itself as being actually a little bit more robust than arbitrary or unlawful might suggest. And so we tend to look at surveillance questions by asking a few different questions. One is the underlying law that establishes the surveillance clear enough so that it provides guidance to the individual as to, you know, what may be surveilled, but probably more importantly, so it provides a kind of constraint around the discretion of the state to carry out the surveillance, right? And we know this just from intuition. You don't need to be a law professor to know this. If the law is written in very broad terms, the government is going to drive a truck through it, and they're going to do all sorts of things that that interfere with surveillance, interfere with privacy in a way that we would probably find problematic. So first standard, we think of it as a standard of legality. Is the law clear enough? And that would be a question maybe for us to talk a little bit about. Is the underlying law that KS analyzed clear enough to constrain the discretion of the state? A second question is, and it's sort of a second and third that are connected to one another, is the action of the state necessary to protect a legitimate government interest, right? So it's sort of one and two. The first part of it is it necessary? That part is very hard for us to analyze right now. I mean, I think that's where the humility part comes in. We really don't know, because it's so early in the pandemic, we really don't know everything about the disease to know what is necessary to track, to trace, to surveil. Nonetheless, I think that it's part of our responsibility to demand that government explain their rationale for why a particular surveillance tool or set of tools is necessary here in order to achieve that objective, which is to protect public health. In another circumstance, if we were thinking about surveillance more broadly, we might examine what is the end, like what is the objective. Here, I think we can be pretty confident that this law and the steps that Korea is taking are for that legitimate objective of public health. But I want to add a note of caution, which is that it may be that we are comfortable with a government like Seoul, like Korea's government, having these tools because it's a democratic country. It is subject to certain kinds of constraints that would ensure that the objective is in fact public health. I'm not sure we can say that about other states. And this is why, while the human rights standards are very important, it's not totally clear to me how portable Korea's model might be when we're talking about its implementation by other states. Other democratic states, other states that have very significant transparency tools, that have robust access to justice, to courts, like we might feel, okay, we're going to allow a little bit of of leeway to the government because there are these other tools to constrain it. One of the problems, and this is something that I'm constantly kind of focused on, since I have to look at the global standards, is whether, what works in a country with strong rule of law, whether it's really going to be effective or even lawful in a place that doesn't have that. So those are sort of the standards that I look to, and I would just note a few maybe elements of, and maybe this could be where, we kind of push the Korean law and try to understand, is it actually achieving lawful, is it achieving its objectives in a lawful way, right? And so the first thing is what I've already said, which is that authorization of surveillance should be contained in precise and publicly accessible laws, right? So that's the first step. I think that this achieves that. Although, like any law, lawyers might say it's clear and accessible, and the general public might say, what? What's that mean? But I think that what you described seems to me like it meets that standard. And also it's an iteration from past Korean experience where previous efforts of surveillance for public health purposes were met with a kind of outcry by the public, and the law changed in order to meet it with different disclosure requirements. So that's the first thing. Is the law precise and publicly accessible? Second, authorization of surveillance of specified individuals, right? And we're talking here about a kind of general surveillance, but if we're talking about surveillance of specified individuals, that should be based on independent evaluation. And I would say preferably by a judicial authority with appropriate limitations in terms of the time, location, manner, scope of that surveillance, right? So it's one thing to talk about a kind of generalized surveillance that is looking at the spread of the disease, what the WHO would call, the World Health Organization would call, disease surveillance. But if we're talking about targeting specific people, it may not be that we need to, in like our normal surveillance world, say you need to get a warrant and go to a court and all that, but there should be some process for getting authorization to surveil a specific, and I would say named individual. A third element, rigorous record keeping. I think this is one of the lessons that we've learned from, which KS knows better than anybody, really, is the importance of when data is collected, that there be a record of that data, in particular, so that anybody who challenges that collection afterwards can look to a record to challenge, right? If data is collected and the record keeping is not rigorous, if it's left fairly open, it makes it extremely difficult to conduct any kind of reliable oversight. And so that record keeping is going to be important. A fourth element, any personal data that's collected should be subject to strict privacy protections to ensure against disclosure of that personal data to anyone not authorized for public health purposes, right? So there should be, first of all, there's the public record keeping, or the record keeping, but the records themselves should not be openly available to people or to government authorities for reasons that are independent of, that are separate from the reason for collection in the first place. And that means that there really has to be some very rigorous controls on who gets to see the data. And this is a question for me. I don't know how rigorous those controls are. If we're talking about private collection of data, so to the extent that, and this is maybe less an issue in Korea than it might be in the United States or other places where there may be private entities collecting the data, I have very serious concerns about the private entity's ability to subject that data to strict protections. Okay, I've only got two more elements. Fifth is some personal data should be expressly excluded from collection, right? So certain data is going to be important for collection, right? You know, infection or non-infection, whether you've had an antibody test or another kind of serological test. I mean, that kind of information will be important, but, and this might sound too obvious, but it should be a matter of law, the content of a person's communications, the connections that a person might have that are unconnected to the spread of the disease. Those kinds of things should not be subject to collection, and the law should be clear about that, so that public authorities aren't able to kind of, you know, willy-nilly collect whatever they think at the moment might be relevant. It should be under some strict guidelines. And then the last element that I would mention is that for many states, the data will be collected and then it'll be anonymized, which is important. But I think that it's going to be very important for states that are collecting information and anonymizing it, that they also demonstrate to the public that that is indeed the case. Again, this is just an issue of we're not going to rely solely on government saying, yeah, it's anonymized, don't worry about it. There should be a process by which they can actually demonstrate that to be so. So I'll stop there. KS, your presentation really triggered a lot of thinking. So I thank you for that, and hope that it may not have given some answers as to how the Korean law actually meets human rights standards, but I think there's some ideas here, hopefully, that we can use to think that part through. So thank you.
David, thank you so much for that. And it was a perfect build on from KS's presentation. And you really placed into context the struggle behind a pandemic such as this, where we're not exactly sure what the full scope and scale of the disease, what it actually is. In fact, it's quite possible that COVID was in the United States before earlier estimates of it being in the United States. At first, it appeared that people didn't need masks. Now we understand that the very tiny droplets that people may exhale may in fact land on surfaces that people will later touch and therefore become contaminated. And so we're learning more about the actual health behind the disease itself. And when we think about how do we keep people safe, then that raises questions about when is it too aggressive or when is it, not, just because we don't know exactly what it is that we are dealing with. And we've seen the struggle state by state to deal with this. And your very point that, typically you wouldn't see yourself as leaning towards, let's look at this as a matter of states' rights. But let me open with saying, to you, one of the areas in which we saw the first coherent efforts behind this was actually at the state level, because this administration actually disbanded the pandemic team that had existed during the Obama administration. And even though there had been warnings and briefings of this administration staff prior to the inauguration, it looked like that didn't go very far at all. And so it really became a matter of states kind of fending for themselves to address this. And so I wanted to start off with you there on that particular point, and to hear more about what you were thinking about when you said, maybe states were doing all right with figuring out some of this on their own.
Yeah, so I am not sure if states are doing well in figuring it out on their own. And when I think of states, and when I mentioned states, I was really thinking about the global situation. Yes. But I think you're right. And this is one of the differences, kind of fundamental difference, which makes it hard to compare, I think. And again, and I'm not an epidemiologist. I don't play one on TV. I mean, I'm just, I'm just suggesting that, one of the differences between Korea and the United States on this particular issue is the degree to which it's possible to centralize this kind of effort. And in the United States, I think this has been a very serious problem. I think it actually, it would have been possible to centralize a lot of this work if the federal government had decided this is a matter of such urgent importance that we are going to centralize this, and we're going to create a mechanism so that what we do and what we suggest is necessary for the United States is actually what's implemented by every state. And in Korea, you don't have that same, federated distinction, so that states might or regions might do something different. I mean, there may be different, the further you get from a capital, some maybe looser implementation of standards, but I don't think you have that same kind of culture of autonomy. And I think that's been a real problem. And it's a long-term problem on surveillance, because if surveillance is not handled by one authority that has the not only the authorization but the power to protect personal data, I'd be very concerned state by state in the United States about whether people will actually agree to the kind of surveillance that has been necessary, or is at least argued to be necessary, as we see in Korea.
Well, historically, it's been actually challenging in the United States. These issues have been marked by our nation's challenge around race. We saw that very early on in the wake of the spread of COVID, not only from the administration, including the president, using very anti-Asian racist terms, but also by members of the Senate. But that wasn't actually unusual, because we've also seen pandemics and national disasters become the kind of space in which insecurities, fears, and even xenophobia and racism emerge. It's interesting, your point about a kind of centralized effort. It's worth thinking about. During the Obama administration, there was not only H1N1, SARS, but also Ebola. And so you think about a kind of organized central platform, sometimes it does the work that doesn't necessarily seem as kind of aggressive to the extent of what KS was telling us about in Korea, but that rather government might be able to utilize its resources in ways that seem less invasive of civil liberties and civil rights.
Yeah, I think that's right. And Michelle, I want to just highlight, just emphasize or underline this point that you made, because I think the last month or so in the United States has really, we've had this discussion about, about policing and brutality and Black Lives Matter in a way that is almost disconnected from COVID. But when we're talking about surveillance, I don't think it's just some rhetorical connection. I think surveillance is a power of the state to conduct some form of invasive, evaluation of public health. And that power, if people, and particularly because, the hardest hit communities have been Black and brown communities in the United States, if their view of public authorities is that the public authorities are nefarious or acting in bad faith, that makes what might be a necessary surveillance technique or effort not only harder to achieve, but from the perspective of those who would be surveilled, whose health would be evaluated, it gives them a very legitimate reason for concern about the state's role. And so, I think it heightens, and this is why you can have standards, but it may also require some of your protections around privacy and also constraint around government behavior to be even more, let's say, amped up in places where there's a very a legitimate concern about the power of the state over communities.
Well, I'm glad that you emphasize that because one of the things that we've seen over time in the United States is exactly what you were saying, play out in myriad ways. So on one hand, vulnerable communities that have long been under the specter of unwarranted state surveillance, aggressive state surveillance, may in fact be very wary of the state imposing itself, right? On the other hand, what's also been very interesting, because of a history of racial intolerance in the United States, many people don't realize that Angel Island and also Ellis Island were actually quarantine stations, right? Sort of the history of that gets repainted as we were just welcoming people, but no, those were actually stations to keep people out. And on the West Coast, very concerted efforts to keep out Asian people, and particularly, interestingly enough, Asian women from migrating and immigrating into the United States. So what's interesting is that on one hand, vulnerable communities concerned about their relationship to the state, but also given the histories of racism in the United States, there have been histories of white people who think that they cannot catch these diseases because it's only the polluted other who somehow contract diseases and viruses, but they are okay. And it's interesting to see that play out even in contemporary times.
Completely.
Yeah. So we're going to pivot, and we're going to come back to a broader conversation that engages all of this. That was a brilliant discussion, David. It was so spot on, including the importance of having real data, right? Data that drives how a state responds. I mean, if, you know, to understand what is the appropriate level of response, much of that must be measured by the kind of data that we're able to collect in the beginning, and not necessarily the ways in which KS is speaking of, but just simply getting our hands on what is it that we're dealing with, you know, how potent is it, how does it spread? Those basic kinds of things are just so critically important. So I'm going to pivot to Professor Park to wrap up the presentation part of this before we go on then to further Q&A.
Hello. I must say that I'd like to thank COVID for giving us a good chance to meet online and discuss the new issues. And this morning I found at least 2 articles from the newspapers, and they reported that there were great concerns raised among the law scholars, especially privacy and data protection law scholars, the concerns about the Korean approach to contain the COVID. My approach may be rather different from what KS Pak said, and I'm going to try to find a balance between the right to privacy and data protection of individuals and health security of the public, including individuals, as provided, as implemented in the Korean Constitution, and also, as David mentioned, under international law. The right to privacy and data protection they are protected under Korean law, including Korean Constitution, but the right to privacy is not absolute. It could be restricted by laws if necessary for public order or welfare, or in other ways, in crisis. And Korean Constitution provides that the health of all citizens is protected by the state. And also International Covenant on Economic, Social, and Cultural Rights of 1966 provides the state's obligation to protect their citizens' health. So the state has to balance its obligation to protect the health of its citizens with the right of its citizens to privacy and data protection. As KS Pak explained, we learned a good lesson from experiencing MERS in 2015. At that time, Koreans, including the government and hospitals were at a loss. The government withheld key information so that Koreans panicked more from uncertainty. Koreans stayed indoors even though the virus was found not to easily spread through casual contact. Thus, Koreans have accepted the cost to their privacy in return for the gains in public health security. The Infectious Disease Control and Prevention Act was amended for collecting the personal information on infected patients and those suspected to be infected, and sharing those information for the public. A bargain seems to be made in that the government's track and trace strategy is legitimized and the public's cooperation in the fight against infectious disease like COVID is mobilized. It is also important to note that transparency in COVID response of Korean government has been assured to gain trust from the public. We have a very strong kind of data protection law, at least in Asia Pacific. And we have the data protection principles as provided in the Personal Information Protection Act, Article 3. They are rather, almost same as those as provided in the GDPR of the European Union. The PIPA, the Personal Information Protection Act, provides the legal basis for collecting and using personal information. For ordinary or non-sensitive personal information, and also for sensitive personal information, the legal basis, one of the legal basis is special provisions in laws. And also we have a special kind of data protection law called Location Information Protection Act. It also provides the legal basis for collecting and using personal location information. One of the legal bases is special provisions in other laws. So in Korea, here we are focusing on the two articles, Article 34 bis and 76 bis of the Infectious Disease Control and Prevention Act. These two articles were newly inserted on July the 6th, 2015, after or during overcoming matters. So these two articles are good examples of such special provisions of laws to justify the processing of sensitive and non-sensitive personal information. Article 34 bis of the IDCPA provides the public with the right to information on the movement path, means of transportation, medical institutions, and contact of the infected patient. Article 76 bis provides the Minister of Health and the other public authorities with the power to collect and access to personal information on infected patients and those suspected to be infected, including their local data. Here I'd like to point out that processing of the personal information on infected patients and those suspected to be infected is applied by the Personal Information Protection Act and its rules or principles. For example, those who are given the personal information on infected patients and those suspected to be infected may not use such information for purposes other than the tasks related to infected disease, and should destroy without delay after completing the tasks and inform the Minister of Health thereof. And those data subjects whose personal information was collected in relation to infectious disease should be informed of the facts relating to the collection, provision, and destruction of such information. And those who are given the personal information on infected patients and those suspected to be infected are subject to the Personal Information Protection Act when processing personal information in violation of the provisions of the IDCPA. So those processing activities under the IDCPA are governed by the Personal Information Protection Act of Korea. However, as K.S. Pak mentioned, we witnessed some problems, so we have to think about the concerns over privacy infringement. For example, the Korea Centers for Disease Control and Prevention and metropolitan and provincial governments released a detailed log of movement of COVID patients, including the time and names of places they visited through the media and related websites. So in some cases, sensitive places like the club or gay club and motels was also disclosed so that their privacy, the visitors' privacy, was breached. So in that respect, in March, the National Human Rights Commission of Korea expressed concerns about excessive disclosure of personal data of confirmed patients as the central and local governments publicized travel histories of infected people. So the Commission called on the authorities to publish the time and names of locations visited by infected individuals rather than providing the travel history of each individual, and specify disinfection and protective measures taken by the public health authorities for those locations. Now I skip a bit and almost I'm in the conclusion. So some observation. Korean citizens' voluntary cooperation. I say voluntary cooperation based on kind of shared trust allowed the government to avoid more extreme measures and maintain a delicate balance between public health security and civil liberties, including privacy. Koreans rather actively joined social distancing. Social distancing has been the main ways of mass protection voluntarily practiced by Koreans. It was regarded as protecting both themselves and others by stopping the spread throughout the community. One successful example is that on April 15th, 2020, we had the general election. A total of 29 million voters participated in that general election, but there was no local transmission of the virus reported during the general election, and after that, for I saw 14 days after the general election. So again, the IDCPA proved to be an effective legal basis for preventing the spread of COVID in Korea. It was amended to contain the outbreak of infectious disease after experiencing MERS in 2015, and again amended to cope with the outbreak of COVID in March this year. With this legal basis, the Smart Epidemiological Investigation Support System platform was developed for automatically analyzing vast amounts of data so as to reduce the investigation time to less than 10 minutes. Before that, it used to take more than a day to determine the movement of individuals who were confirmed to be infected using their mobile phone location information, credit card payment history, and CCTV data analysis. Now, still, we have two tasks in the future or near future. First, sensitive personal information like health information relating to COVID may be further processed through pseudonymization without data subject consent for scientific research purposes to develop vaccines, as well as for statistical purposes and archiving purposes in the public interest. This legal basis will be effective on August the 5th this year. It was inserted, in February this year. And finally, as raised by many experts, there is a good justified concern over the approach to contain COVID. So the concrete and reasonable standards on sharing and disclosing the information on infected patients and those suspected to be infected should be developed so as not to unduly infringe their privacy. The right to information for health security purposes was found to lead to privacy infringement. For example, processing such as disclosure of certain personal information on the movement paths in relation to a visit to certain places raised privacy concerns. So, excessive disclosure of personal data should not be allowed, while the spread of infectious disease such as COVID should be effectively prevented. One final remark may be that those laws and rules and implementation by the Korean government is conditional on the crisis. It is also to be temporary while it is needed. So as Kyungshin Pak mentioned, the QR code and those personal information, but very limited amount of personal information should be automatically destroyed in 4 weeks. And also I said the Iccpr requires the destruction of personal information collected soon after, without delay, after the completion of the tasks relating to infectious disease. Without delay, I understand, may mean only 5 days. So this process, these activities involving data, personal data process is again governed by the Korean law on data protection and also its principles. Okay, that's my presentation. Thank you.
Well, Director Park, Professor Park, thank you very much for your comments. I see how these presentations fit together across the spectrum. And your presentation certainly begs the question about what does it mean to volunteer? And that's been a question embedded in the sort of intersection of law and technology for quite some time. When people click on a particular thing that they see online, how much of it is voluntary, that they're sharing their information or not? Some people say, well, of course you ought to know when you're getting online, you click on various things, that you're opening yourself to certain computer algorithms that might take whatever it is that they need. In the case of thinking about COVID, you're absolutely right that across the world, and certainly in Korea, there have been questions as to what is voluntary or not. This kind of sheltering in place in the US has been done quite a bit. You say that this is the nature of what happened in Korea, and that privacy is not an absolute. With thinking about the presentation from KS, do you think that where would you see the boundaries in terms of what is permissible in Korea? Can you see at any point where the government perhaps went too far, or not at all?
Yeah, first, there must, in the implementation of the rules of law, there might be the excessive application or implementation. So the law provides the people the right to information, to give them a chance to protect from the outbreak and the spread of the COVID. But the law is, as we know, is to be generally worded, not to be so detailed. So our law says the information to be disclosed covers movement paths, means of transportation. So when applying this provision, the authorities may have different ideas on how far they can go by disclosing on movement paths. So fortunately, we have the Human Rights Commission, and the Commission rightly raised the concern to our government. And then I understand, especially municipal governments, they corrected, or rather made some restraint in disclosing those personal information. So we are now, I hope we are now moving for the balance between the privacy and the health security.
Mm-hmm. I really appreciate that. And one other issue that comes up in your response right now is also the importance of organizations outside of the government that monitors both what the public needs and deserves in terms of human rights, and also what are the sort of monitoring the limits of where governments can go. And you mentioned that that was part of what happened in Korea. Can you explain a little bit more about that?
Actually, I think that could be answered more rightly by KS Pak.
Okay.
I mean, his main interest is in protecting human rights in Korea. But I said those rules and the activities of the government and of the people are, again, as long as we are facing crisis of human health security. And as KS Pak mentioned, we have some asymptomatic patients. And also I found that around 10% of the confirmed infectious patients, 10%, we do not know how they were infected. So we have great concerns who and where our crisis, our source of crisis resides. So in that sense, I think for the moment, we are experiencing or we are testing a new case, but the law, infectious disease law, was amended a lot when we first experienced a great crisis in 2015, 5 years ago. And now, after 5 years ago, somehow it seems that we have the right law at the moment. But I think sometime later, we should assess again what was wrong and what could be better.
Well, I want to take this opportunity to open up to our other guests, and as well, if those of you who are watching online have questions, please feel free to bring those questions to the fore. So opening this up to UKS, David, and Director Park. So I'd like to pivot with the last question that I asked. What's the value of organizations outside of government keeping watch on government during times such as these? I mean, let's be clear that during the aftermath of 9/11 in the United States, there too, one saw the infringement on civil liberties with unwarranted searches of people's online use. So it's not as if it's just COVID that brings these questions up for us. There have been prior times of national disaster where in fact it's important to monitor how far government may see its authority. And how exactly does that monitoring take place? How should it take place? And I'd like to open that up to UKS and also David.
Well, again, on public disclosure of the information about patients, the country's National Human Rights Commission has already spoken, and the authorities, the health authorities, have complied with recommendation and reduced the amount of information. But I mean, what's bothering me is that the commission has not spoken. Well, maybe I should call the commission and ask them why not. But they have not spoken anything about the government's initial acquisition of the information, which seems to be both more invasive and more efficacious, more valuable for prevention purposes also. Maybe the commission is not speaking because of its value for public health. But as David, you know, he's a UN special report. He's a UN human rights body by himself, and he's recommending that location tracking on specified individual probably should be based on warrant. So I think that the monitoring by non-government agencies has been not very effective in terms of breadth, in terms of comprehensiveness of monitoring. And well, if we take into account the Constitutional Court as one of those bodies, we'll see how the Constitutional Court rules. We are taking this non-judicial, non-consensual location tracking law to the court, and I'm pretty sure they will strike down some parts of it as being too broad, as being too unclear. But will they strike down the core of it, the core concept that the government can access the data against the subjects well? One point that may or may not belong to that the core inquiry is something is inspired, well, is related closely to David's second point about the specified individual surveillance. So I told you about the Itaewon case where the whole area, the whole commercial area was subject to surveillance, and 20,000 people who were there on particular night were identified and contacted. So one of the persons just went to a restaurant, didn't go to any of the clubs where the patients were found. He just went to the restaurant, and he received a notification that he should go test himself. And he thought that his privacy was violated because, you know, just being in the restaurant in no way puts him in the category of a suspected contactee. You have to be at least in the same building. But the government is drawing a broader circle of who suspected contactee is. Now, I think that we have a good chance. I think the Constitutional Court will say, you know, this is too unclear. The term suspected contactee has to be more granularly defined. But that brings me to the next question. Or when he was identified and contacted, the government didn't get any other information about him other than that he was in the area. So maybe that's a minimum. Maybe their privacy infringement, maybe the privacy interest restricted is not that much, because all the government found out was that he was there in the area. So maybe this should pass. And also the government didn't know, the government did not care to find out the identity of the person. All the government acquired was just a phone number of the person, that was in that area. So given the government's efforts not to actually get the full identity of the person and the amount of information on that person that was acquired by the government, maybe this should be allowed without warrant against the person. In the US and Europe, the term that they are using is a contact tracing. Now, the politically correct term is exposure notification, because by contact tracing, what they mean is identifying people who were in contact with the patient and just notifying them that, you know, they should take precaution, they should either quarantine themselves or test themselves. But the problem with exposure notification is you don't know who to notify, right? So far, what has been done is just putting it out there, just publicly disclosing the trajectory of the patients. But what Korea is doing is actually sending personal notification to each person who was there, because we have this law. We know who to notify. So maybe if we limit ourselves to just finding out who to notify, and then do any, you know, and don't do anything more, then maybe this should pass international human rights muster. Of course, I'm kind of checking out David's facial expression, but we'll see. Just to add to that, so after so this Itaewon area surveillance, it was prompted by the finding of patients at these gay clubs, and they realized that having people come forward for testing may be too stigmatizing for the people who are there. So what the city of Seoul proposed was anonymous testing. Probably this is something that was never done in other countries. They'll test people without checking people's identity. Of course, if the person is found positive, then they'll check the identity. But this invited just, everyone who was at the Itaewon area just to come and get tested without producing any identification. So maybe this is the way to go. I mean, this is one way the government can minimize the information that they collect on people.
So
what do you think?
So David, I don't know if you wanted to add to that quickly, because then I want to pivot to Joseph, who has a couple of questions that are in the queue that Joe's going to tee up for us.
I would say go to the Q&A.
Okay.
Because some of this might come up, because I think, KS, your points are really, I think you're articulating our second panel also, because if you're litigating these issues, I think it'll be really interesting to see both like where you think there are soft spots, like there's room to litigate the privacy questions that you're talking about, and also to game out how a court in the midst of a pandemic will actually, and in the midst of a pandemic where there's so much uncertainty, how it will treat these kinds of questions. And I frankly I'm not sure. I mean, I think you're pinpointing some really important human rights / privacy questions that and the Korean courts have been pretty robust in dealing with privacy law questions, but I don't have a good read as to how they'll respond to the arguments you just made.
Well, I think the bigger question, I mean, you talked about the second panel, but I think the bigger question to deal with is this. I mean, look at how contagious this disease is. In the long term, there will be, I mean, no single country can be safe alone. I mean, they are saying it's contained in Korea, but Korea cannot continue to do this 14-day quarantine on the new arrivals from overseas, because Korea's GDP, 85% of Korea's GDP relies on export. So we cannot control the entry anymore, which means even if it's contained here in Korea, the disease is gonna find its way back into Korea.
And I want to pivot to Joe with those other questions, but on that point, even thinking about what this means in the US, COVID-19 took barely 2 months to surpass the deaths suffered by Americans in 19 years of the Vietnam War.
Okay.
And while the Vietnam War is long over, COVID-19 still rages in the United States. And I think that context is really important in all of our communities around the globe. I think that puts it in context. Americans remember the Vietnam War as ill-fought and so many deaths, but that was over 19 years. In the first 2 months of COVID, we lost more people than we did in Vietnam. So Joe, let me pivot it over to you for questions in the queue.
So I have one question from the from the Q&A tab, and let me just say to the audience that if you would like to ask a question, that's the most effective way to do it. And I have one. We're on Facebook Live, so I'm getting text messages as well. So the first question is for Professor Kyungshin Pak and for Park No-young. So this is about the Itaewon incident, but I guess it's less about sort of preventing privacy breaches and more recourse after the fact. In the absence of any comprehensive anti-discrimination act in South Korea, are there effective remedies or other measures for those who have been victims of outing and other privacy infringements with regard to their identities as having visited clubs in Itaewon?
Yes, but you should go ahead.
Would either of you like to take that?
I think this is a legal question. I think that it really depends on how much information has been disclosed by the authorities. Actually, I know that here in this instance, it's not the authorities that they disclosed that the clubs were gay clubs. It is one newspaper that has tracked down the nature, the feature of these clubs, and then reported them as gay clubs. And I think that, well, I have a good answer to this. if the Constitutional Court finds that too much information has been disclosed, because right now the government is not disclosing at-risk areas. The government is disclosing trajectories of patients and suspected contactees, and by disclosing one gay person's trajectory, if the government has also disclosed by inference, the sexual sexual orientation of other people who are in the same club, if that is a credible inference, maybe there can be suit for damages under Korean law. But I think it will depend on case by cases analysis that escapes the scope of the seminar.
I may add one thing, but after my remark, I understand Dr. Myung-Yeon Jung may say something about this issue or on other issues. Yes, privacy. Privacy is the right protected constitutionally. And if there is any damage toward the reputation or dignity, that it may be handled in the courts. And also Itaewon and clubs, including so-called gay clubs. So this kind of information on sexual orientation is one of the sensitive personal information which is specially protected under the Korean Personal Information Protection Act. So I think, I'm not so sure whether we have such anti-discrimination law in general, but I think those breach of privacy or breach of data protection involving such sexual orientation, sensitive information may be handled rightly.
Thank you for that. Joe?
Yes, thank you. Here's a second question, and this is about the U.S. context, and this is a question about contract tracing at the state level. And so it says, can you ask whether any of the panelists know of any of the states that are doing contract tracing beyond interviewing the patients by collecting data? Is it illegal, for example, for states to collaborate with phone companies to look at data? Or what about QR codes, mandates, other such mandates? Are these sorts of measures possible to implement right now?
So I'll turn it over to the panelists after just saying that recently there has been at least one credit card company that has collaborated with public health officials to be able to show that an increase of COVID-related diagnoses has been related to greater use of restaurants in some communities. So there hasn't been announced by any particular state anything near what is being described in Korea, and virtually not much at all with regard to contact tracing. Now, my sense is that states are still figuring this out, and one tragedy of all of this has been the ways in which there have been public health officials that have been attacked and threatened with effigies on their front lawns, with their families threatened and whatnot. And those have been in instances where public health officials have just simply articulated, please use your masks. You know, please shelter in place, please don't go out unless it's necessary. And, you know, in the US, what we have seen are some pretty robust attacks against that. Here in the state of California, in Michigan and other states, in fact, quite ironically, you see the Confederate flag making its way up to Michigan with people using that as part of a symbolic gesture in fighting back against government warnings to keep safe. David, do you want to add to that, or you, KS?
I'd like to hear what KS says, but I would also agree with you, Michelle. I mean, I think that well, there's two separate issues, but one is the very severe politicization of measures to address COVID, you know, in the United States makes me really concerned that we're going to be able to do the right things on these issues. And by right things, I mean the things that public health officials, you know, where there's a consensus about things like mask wearing, for example, where there's an overwhelming consensus of the importance of that, and yet it's been politicized. I mean, I do think there are restrictions on the second point in terms of what can be collected in an involuntary way,
Sure.
either by public or private actors. And that's a good thing. I mean, that's a good thing that there's no, that involuntary collection is prohibited, but it does beg the question for us as to whether, you know, Korea was pretty far ahead. They were prepared for a pandemic because they had the experience of MERS and other potential diseases.
We too have had an experience too, H1N1. That was from the US.
Right, true. I guess the experience was that they experienced it and responded to it in a legislative and public health way that laid the groundwork, and we didn't do that. And that's and especially in the environment that we have now, it's hard to see that happening anytime soon.
And let me add that also Spanish flu was also mainly American thing. I mean, not mainly American thing, but it began from the US as well. Yeah.
Sure. And that's actually a really important point to underscore, KS. And that is that in the narrative behind pandemic and outbreak, I think that there is a mythology, a kind of false impression that many Americans have, which is that these types of things come from someplace else. They don't emerge from the United States, but in fact they do. H1N1, that was US, which spread across the world, and there have been other instances of health crises that have spread from the United States globally. And I think the point is that, you know, really international collaboration and cooperation is what's really important, and not this kind of game playing of pointing fingers, because inevitably the finger points back at home too.
Yeah, I think that this panel is important not just for Korea, but for the US and the whole world, because let's say we figure out a tracing system that somehow passes international human rights muster and yet achieves the efficacy that the Korean system is achieving based on involuntary collection, right? Somehow we figured out kind of internationally human rights compliant way of involuntary collection. Will the US adopt it and, you know, to achieve the same kind of efficacies detection and prevention system? Well, I mean, we talked about politicizing, and you know, the Palm Beach County, Florida, just voted to mandate wearing masks in all indoor gatherings. And I saw a video clip of people, mainly from the Christian right, and Trump supporters. I could tell them because they were wearing shirts. They were speaking at the county hall. And as you listen to them, you will think that the strongest supporters for privacy, the strongest privacy advocates in the US are Trump supporters. They were saying no to everything. They were saying no to masks. They were saying no to any type of a disease surveillance. So I can see that this will really kind of complicate formation of a political will strong enough to really carry out human rights compliant and yet effective disease prevention. I mean, just looking, I'm not an epidemiologist, but I can see that we are in it for the long haul, and disease will come back, and it's coming back in even Korea. I'm really worried how even the even we are not prepared in very many ways, including the political dimension.
You know, and I wanted to take an opportunity to further expound just a little bit to help fill in a little bit more of the U.S. context. I think one has to be careful not to sort of do the U.S. exceptionalism, which is to sort of place the U.S. at the forefront. But I think in this conversation, given that this has come up and some of our audience is, or maybe much of our audience happens to be based in the US with the kinds of last question that we had, is to actually reflect a little bit more on law in the United States. And so some very fundamental questions have emerged in the US space with regard to coronavirus, and also the interactions between constitutional rights, state police power, and federalism. For example, what happens to be the limits of actions that a government can engage in during a pandemic? And these are the kinds of questions that are being raised across the United States. You know, one of the first was whether governors could even require that there be a shelter in place or a quarantine. And if you follow US constitutional law as being the law of the land, well then, for centuries, government being able to impose quarantine has been the law of the land. In fact, the probably earliest iterations about quarantine being legitimate and constitutional date back to 1738. There's an 1824 case where the US Supreme Court, Gibbons v. Ogden, where the Supreme Court specifically references state authority to regulate health and erect quarantine laws. 80 years after that, in a very famous case, which is being talked about quite a bit now, Jacobson v. Massachusetts in 1905, the US Supreme Court, in a vaccine case, iterated that states may take upon efforts in order to protect health and safety, limit privacy or limit what or impose certain conditions on individuals in order to protect the broader health and safety. And that's a key case when thinking about these particular times. But I think, KS, you know, what you've described and also what you've given to this discussion in very nuanced ways, David, is to think about how historically governments have also, including the US government, has deployed protecting the public's health as a justification when seeking to harm or undermine civil liberties, particularly of vulnerable groups. And I've spent quite a bit of time in Korea, you know, and KS, when you talk about 81 and talk about, you know, LGBTQ persons, right? We're looking at vulnerable people, and it's often vulnerable people who get hit first with the government, you know, reaching in certain ways and constraining civil liberties and civil rights. And certainly we've seen these patterns in the US dating back to eugenics in our country. In fact, eugenics, long before Germany in the United States in 1927, the US Supreme Court upheld a eugenics law from Virginia. And that law basically used public health as a reference point for justifying the non-consensual non-consensual sterilization of people in the United States. You know, in the end, it was a platform that led to tens of thousands of people being sterilized against their will in order to spare the public from being swamped, as the Supreme Court said, with people who are socially and morally unfit. That very law, which the US Supreme Court upheld, became the foundation for the law that was used in Nazi Germany in order to impose eugenics platforms, not only against Jewish persons, but also other unfavored or disfavored communities. And the final point that I'll make is that we've seen also in the time of this very pandemic, other efforts to constrain and curb civil liberties. We saw that in the reproductive health space, you know, just out of nowhere, you know, state legislatures that had tended to be anti-abortionist and conservative saw this as an opportunity to limit abortion out of nowhere just because we were in COVID. So it is true that in these spaces we've seen over time where civil liberties and civil rights can be constrained and that a government might use, a pandemic, a national disaster, as a proxy for carrying out an agenda against, communities, sometimes disfavored individuals, such as during eugenics, or in this particular case, carrying out, an agenda that's anti-abortionist just because we happen to be in COVID. Joe, do we have other questions coming up in the queue?
Yes, I just wanted to acknowledge that Noyoung Park, Dr. Park, has invited a colleague of his from Korea University who's an expert on data projection. Her name is Chung Myung Hyun, and I believe she has a few comments that she wants to add to our discussion.
Okay, thank you very much. And I'm honored to be in a part of this great discussion. As one of the panelists already pointed out, at this moment, we could not clarify the causes and consequences or impact of the disease. And this is a very exceptional situation, and we have to have in mind at this moment. And the disclosure of location tracing of COVID-19 patients brought many private concerns, and also public awareness is quite high on this matter in Korea. And already Professor Park pointed out the Infectious Disease Prevention Act clearly stipulates to promptly disclose information with which citizens are required to be known for preventing the infectious disease. We also have a regulation to order wearing safety armband who violated self-quarantine guidance as an infected patient. In the survey, 80% of the citizens agreed to wear a safety armband and 14% opposed it. Also, even after the number of patients are decreasing, maintaining social distancing policy is supported by more than 60% of the citizens. According to the data management person, the disclosure system under the infectious disease prevention system itself is working according to the limited purpose principle, which is one of the important privacy principles. And the data published by government are through the de-identified measures, and their identifiers are removed. The problem arose from the situation such as the eternal clause. When authority need to identify and reach patients' contactees and possible contactees, the patients are accidentally identified, and these consequences were not foreseeable at the first stage. And media reports are also contributing these consequences. And governments are also aware of this situation and trying to figure out these problems. This means so far, Korean infectious disease prevention system is based on legitimate legal basis and operated lawfully in this emergency situation. And governments are also very aware of this criticism with Korea's disease surveillance and trying to balance between public interest, including public health concerns and citizens' privacy. Okay, this is the end of my comments. Thanks.
And if I could ask, take the MC's prerogative and ask a question myself, I'm so enjoying this conversation. It's so interesting, and I'm really grateful to hear, to benefit from the expertise of all you wonderful legal scholars. But I guess I'm asking for this question for all the people that are not legal scholars in the room. And I guess I want to throw out two phrases that I've heard a lot, that we've all heard a lot lately in the course of this pandemic. One is the new normal, right? And the other is a state of emergency or state of exception. And those two things very much rub against each other. So a lot of this kind of surveillance is justified by a state of emergency. This is very needed at this time, right? But on the other hand, when does the state of emergency become the new normal? So I guess the question is, legally speaking, how do you maintain a firm boundary between one and the other? How do we make sure that the state of emergency remains just for the emergency, and we prevent that from just becoming this new sort of opening up a new set of practices that we just become increasingly used to, and that just become part of the new normal?
That's a really great question, and it's a fundamental question in so many levels. And I think what it highlights is how, it's possible to talk about surveillance of the disease through a narrow lens of privacy law or surveillance law or whatever it might be. but we cannot have adequate oversight without access to justice, without access to the courts, without, as Professor Park said earlier, access to information about the nature of these measures. And so, you know, we really have to see the connection. So if we think about there's a public emergency and there's a need to deal with the threats during that emergency, we still, in fact, it's as important as any other time, need to be able to hold government to account to ensure that they don't go beyond that remit. And I think that's just absolutely essential to any system of surveillance.
I agree.
I think we're up against at the end of our time. First of all, I want to thank all of the panelists for a really invigorating, fascinating discussion. Thank you so much for your time. Just an apology. KS was corrected me at the very beginning. I neglected to mention the Korea Law Center at UCI, the American Law Center, and the Cyber Law Center at Korea University Law School as co-sponsors of this event. And I also wanted to thank KS, Summer Kim, and Sean Cho for their work in organizing it. I will leave the last word for Michelle, because I think you've done a wonderful job moderating us. If there's anything you want to say in closing, I'll give you the last word.
Oh, thank you. First, I want to thank you and all of our co-sponsors that you have just mentioned in bringing us together today. It is the silver lining, I suppose, of COVID. And let me say this, that government infringement on civil liberties and civil rights as we move forward should be driven by science, confirmed by medical evidence, and tailored to address the health harms and threats. It's not an all or nothing proposition, because that in fact would be too simplistic. Rather, when we're thinking about protecting the public's health and safety during COVID, it really requires prioritizing the public's health while safeguarding civil liberties. And I thank you for allowing me to be with you all, and thank you, our wonderful guests, for participating.
Thank you.
Thank you.